So my name is Phil Goldberg, and I'm an attorney at Shook, Hardy & Bacon. Before I started practicing law at the law firm, I worked in politics for several members of Congress and then in public relations, and I know we had a great discussion with Marcia yesterday on PR issues. So I can't pretend to hold a candle to her, but if anyone didn't have any questions that they didn't get answered yesterday, she'll still be here after my talk today. But we can try to answer some of them. So when I look at the animal law movement and developments in animal law, I'm looking at it through each of these three strategic perspectives: the politics, the media, and then the legal change in the law. And so I hope that this morning we're going to build on some of the great discussions we had yesterday, and then some of the discussions we're still going to have today, because a lot of these themes, as you've no doubt noticed, intermingle. And I think the NAIA did a great job in putting the program together, because a lot of these topics really do complement each other very well. So the overarching theme that I want to talk about today is the development of animal law and its impact on animal ownership rights. And we've seen significant change in the last 15 years in this area of the law, in a significant change in redefining the legal status of animals, and then in turn redefining the ownership interests we can have in our own animals. And then I'm going to spend some time talking about something that I've been working with NAIA on and other AKC. I know Margaret Poindexter's here, the Animal Health Institute and others, on which is the issue of emotion-based damages in animal injury litigation, and the effort by some in the animal rights community to put those damages into the litigation as part of giving animals rights above property and something more akin to what children might have. And I want to underscore one point, and that typically is something I need to plead people to understand, but here you guys all get it, which is great. And that is that there's good animal-loving people on all sides of these issues, that no one group or one perspective has the mantle on being pro-animal or the mantle on being the only people who care about animals. We all care about animals, that's why we're here. So it's very nice to be among friends. So the baseline legal point here, and I'm trying not to make this a law presentation or over legalistic. So if I start to sound too wonkish or too lawyerly, someone raise their hand. But so the baseline is that animals are your property. And like with any property, you have the rights to control what you do with it. And that means training, housing, food, welfare, if you got to put an animal down, slaughter, all those different things that we do with animals. That's because the animals, you have a property right in the animal and you get to do that. But there are limits on ownership rights. So if you have real property, there are zoning laws, or there's eminent domain. There's things you can and cannot do with your real property, and there's things you cannot and can do with your animal property. And what the limits of those are is changing, and how we answer the question of what we want, what we can't do with our animal property is going to affect everybody in this room, regardless of where you are in, whether it's in agribusiness or in companion animals or enthusiasts. It's going to, or entertainment, it's going to cross the whole spectrum. So about 10 years ago, there was a significant, about 10 to 15 years ago, there was a significant change in animal law, in sort of building the seeds for animal lawyers and as a discipline. Again, it was about 10 to 15 years ago. And it's created this dynamic, which actually is in some ways exciting, in some ways scary, to be at sort of the beginning stages of an organized, deliberate effort to change a law and a whole body of laws. And over the past few years, this has been written about in the Boston Globe, in other mainstream newspapers, legal newspapers, I think we have a quote coming up here where the Pennsylvania lawyer talked about this, where the environmental law movement was maybe 30 years ago, is where we're seeing the animal law movement today. And a lot of this got started, at least at the law school level, through Bob Barker of The Price is Right fame. He donated $500,000 to Harvard Law School to fund teaching, research, and student opportunities in the field of animal law, especially animal rights law. He then doubled down on that, gave another $500,000, and then gave $1 million to each of Columbia, Duke, Georgetown, Northwestern, Stanford, UCLA, and University of Virginia. These are some of the top law schools in the country. Now all we're developing animal law programs and had the resources to do so. In 1999, there were 6 law schools that offered animal law programs. There's now somewhere between 120 and 140. The Animal Legal Defense Fund had a smattering of chapters 10, 15 years ago. I've seen somewhere they've had somewhere between maybe even up to 180 chapters in the U.S. and Canada, about 120, 130 or so in law schools in the United States. The first casebook that was dedicated just to animal law came out in 2000. It's now on its 4th edition, and now there's a second casebook on animal law. And you have bar associations. There's an animal law committee in the American Bar Association. Each state has bar associations. There's animal law committees in probably about half the states, if not more. And this is one plea for the lawyers in the room. If you're a member of the American Bar Association or you're a member of a state bar association, please join the Animal Law Committee. Because a lot of times, if our voice is not represented at those meetings and in the votes and the things that are done, then we're not going to be happy with what comes out at the other end. And so it's important to make sure that we're part of this and we're not simply yielding the floor to those who may espouse viewpoints that we may not agree with. Professor Favre, whose quote is up here, talking about sort of the wave of individuals passing through these law programs, he became the first law professor that I'm aware of, and I believe that I've heard that he is the first, to become a full-time professor through his work on animal rights and animal law. And so this is a maturing field of law, but the one thing that I also want to leave you with is not monolithic. It is the idea that everyone who comes through these programs is going to be a PETA or HSUS or what have you, animal rights lawyer, is not as true as it may have been or as people may perceive. The folks who do focus on animal rights, their goal is to give legal rights to animals and to end animal ownership because they don't believe that animals should be owned. Those who focus on animal welfare want to focus on improving the quality of life of the animals themselves. And sometimes these agendas intersect and we work together, and sometimes they don't, and that's when we have a lot of the difficulties that we've been having. But a lot of the people coming through these programs are just as likely to end up working for the companies and businesses that service animals, that make animal products. Many of the people that you work with, or maybe in this room yourselves, are going to be lawyers who came through the animal law programs because that was their interest and this is where they want to go practice. And so the second challenge I want to lay down, in addition to joining the local bar association and law committees, is to go to these law schools. We heard about Lewis and Clark yesterday. Go to these law schools, talk to the lecturers who are working on these and professors who are putting these courses together, and ask if you can come in and guest lecture and talk about what animal law means to you, what it means to your business, what it means to your community, and offer that perspective because there's, I was, about a year ago, I was invited to the George Washington Law School where I went in D.C. They had the Animal Legal Defense Fund, has a chapter there, and they were having a careers panel, and they asked me to come speak because they know that I do work in animal law areas. I don't think they knew exactly what I did, but they invited me nonetheless. But what I was really grateful for was there was a panel of 4 of us, and 2 of us were on sort of the corporate business. One of the other attorney was really more of a local attorney in a small firm, but she often did. She looked for opportunities to get involved in matters that dealt with animals, and oftentimes was representing the defendant in these cases, and then and there were a couple other attorneys on the dais. One was working for the government, and another was, I think, with a wildlife organization. So we were able to present a nice balance to the students who were there, and I can tell you at least a third of the students afterwards came up to the other women and I and said, "How do I find out more about what we can do? And I don't necessarily want to go the rights, in the animal rights direction." And so, putting a face to what it is that we do in our interaction with animal law, I think is very important. And I encourage you to go to your local law schools and see if you can, and you don't need to be a lawyer necessarily, but go to your local law schools and see if you can help out and be part of either a career panel or a lecture in a class and talk about an issue where animal law intersects you. So when we look at the animal law movement over the last 15 years, bless you. There's two sort of key trends or themes to think about. And one is there's a blurring of lines. And the two is the folks on the other side are incredibly opportunistic. So as lawyers or business people, we think in our buckets. There's work animals, there's animals we eat, there's companion animals, there's entertainment animals. They don't see those lines. So when we see what happened, with Michael Vick or the stories after Hurricane Katrina, we see those as companion animal issues. When we see, that we read articles about, it was a year or two ago, I think Novartis' chief executive had one of his houses blown up by an animal rights activist. We see that as a research issue. We see decisions on antibiotics and the Animal Legal Defense Fund's recent effort against the so-called ag-gag bills that stand up for animal land and animal ownership rights as agribusiness issues. And we see lawsuits against circuses as entertainment issues. But they see all of these as opportunities to change people's minds because the public and they don't try to distinguish between one of these circles and the other. They see them all as overlapping. And if they can convince people that we shouldn't be doing something in this area, that sentiment will translate over into the other areas. But at the end of the day, most Americans are not going to buy into the end game of the animal rights community. They're not going to buy into the end game of trying to end ownership interest and rights. And so they look at incremental change. They're looking at making difference over the course of years, not quarters or annual budgets. And they rely on the fact that most people love their animals. And I think if you ask most people, including me and everyone in this room, would all say that we're pro-animal. 2/3 of Americans own animals, but like us, they also generally eat meat, going to circuses, owning pets. They want medicines tested on animals before being tried on humans. But we also wince at pictures of abused or sick animals. And we should, because I think as we heard someone say yesterday, do the right thing and tell people about it. I mean, when we see animals that are injured or are abused, it does turn our stomach, and we don't want to see that. So what the animal rights activists do is several things. One is they find issues that are hard to oppose. They're the warm and fuzzies or try to isolate sort of bad behaviors or the worst conduct. And then they try to segment us into different buckets so that we don't come together and join efforts. And so their policy or legal play is to really chip away at the rights, not necessarily to get the end game at once, sort of the death by 1,000 cuts. And their media play is to rely on the sympathies that they can create through some of the videos or some of the some of the conduct that they're pointing at. And so let's look at some of the campaigns and their successes over the past 10 to 15 years. And I'm not going to get into a whole lot of these on the substance, and a lot of them were discussed yesterday. But I want to talk about this from a political, media, and legal perspective. So we heard a lot yesterday about, Greg talked about the sow crates, and others did as well. And let's look at the political strategy. In 2002, sow crate ballot initiative first appeared in Florida. Are there a whole lot of pig farms in Florida? No. it was an opportunity for them to roll out this idea in a state where there's not going to be a whole lot of local opposition, talk about an issue that they thought people would understand and get, test out their theories, minimize, as I said, in-state opposition. So there wasn't a whole lot of people to get out there and say, no, don't do this. Flesh out some of their opponents nationally and kind of learn where we're all going to come from and get that experience. And then they won. And then in 2006, they went to Arizona, maybe a little more of an industry there, and they're able to win there as well. And then in 2008, they went to California, and obviously were able to win in California. But that is not the end. There are now, I think, Rhode Island and potentially Massachusetts this year became, I think, the 9th or 10th states with sow crate legislation or sow crate laws. And now it's being done through state legislation. Again, some states that don't have a whole lot of industry. But what they're doing is they're building momentum and building a consensus in areas where we're not really competing because we don't have often the local interest. And then they can go and apply the business pressures and ask companies and industries, either at the end users, the restaurants, or to the industry, and try to get people to say, okay, well, we won't use that, or we won't do that practice. And so it's all intertwined, whether it's ballot initiatives, whether it's legislation, there's litigation. They all try to affect the same change and get at it from slightly different ways and trying to find out where the opportunities are. The puppy mills ballot initiatives and legislation. Right now, there's 22 states with laws addressing commercial breeders. My firm, Shook, Hardy & Bacon, is based in Kansas City. I'm in our DC office, but we're in Kansas City, and we have a very large agribusiness practice there. And a few years ago, I was addressing, there's something called, I think, the KC Animal Health Corridor and the agribusiness community around Kansas City. And we were talking about these kinds of issues, and they had a puppy mill ballot initiative. And we were talking about that even if you weren't in that segment of the industry, this is something we just can't let happen without engaging. And so we talked about the need to talk to legislators, get people in the community understanding, so that even if this did pass, that we were going to be able to shape it and then work with it from there, and this wouldn't be the end game. And I was just back there at the Missouri Governor's Agribusiness Council back in January, and we were talking about how we were able to do that, how Missouri legislature took this ballot initiative, then went in and made some of the changes that needed to be made so that it wouldn't have some of the harmful effects. But this can't be just a Missouri experience. What they do is they're taking their victories and they're going from state to state to state. But what happened in Missouri can't just be a Missouri victory. We've got to take that and now in the next state say, well, they tried that in Missouri and then we were able to get these changes. So let's start a bill with these, let's adopt the Missouri bill and start using our victories to lay the groundwork in other states. We heard yesterday the foie gras examples. People talked about circus lawsuits. What I also want to talk about is in the family law context and in companion animals, because this is another area where there's a lot of sympathies among the general public and where they're able to make progress, but make progress in a way that's ultimately going to intersect with people in industry or businesses related to animals. So the obvious one, if we look back 15, 20 years ago, are animal cruelty laws. In the mid-90s, there were only 7 states that had felony animal cruelty laws. Last year, Mississippi became the 47th. I can't stand here and tell you that I don't agree that we should have laws against animal cruelty. And I think we all would agree that no one should be cruel to animals. But this is a legal distinction between your property right in an animal and the property right in other types of property. We all agree with it, maybe some don't, but it's a marker, and that's where people were willing to go. And so if you look at other areas of family law where they're elevating animals above other types of property interest and equating them more in line with children, there was a 20 states now allow you to put domestic pets into domestic violence restraining orders. You can't say that about any other kind of property you have. 20 states. When Leona Helmsley left $12 million to her dog, oh my God, that was national news. Became a laughingstock. Taking care of pets after you die is a regular part of trust and estates practice now. That's not that much long after the Helmsley situation. Divorce cases. In Massachusetts a couple years ago, we saw a veterinarian was called to testify as to which owner the pet liked better. One judge had I'll call them the mom and the dad owners, at opposite ends of the courtroom and did the come here test. Have them both call the dog and see which way the dog went. But there's two changes, two small but direct attacks on animal ownership that I want you to think about in the area of family law. The court-appointed attorney is the first. Within the last couple of years, we've seen the first court-appointed attorney to the dog in a divorce case. That is giving direct rights to the pet. And just this year, there was an unfortunate incident where the two families are very good friends. The dog attacked the 5-year-old child of the other family. And the owner of the dog was horrified and wanted to put the dog down. And the court appointed an attorney for the dog to represent the dog's interests before she could put the dog down. Are we going to start seeing court-appointed attorneys for livestock, for racehorses, entertainment animals? We don't know, but it's starting. It's starting to find its place into the law. Guardianship laws. We were talking about this a little bit earlier this morning. Berkeley is one of them, where there are some towns that are taking their ownership, the word ownership, out of their codes or town ordinances and replacing it with the term guardian or guardianship. And the theory is that if we all think of ourselves as guardian of our pets and not owners, we're going to treat the pets better. But guardianship and the concept of guardianship is a legal concept, and it has a whole lot of rights and obligations that are attached to it with respect to the ward that you're a guardian over. Right now, the folks who are trying to get these ordinances changed say, well, we're not interested in that. We just want, this is about warm and fuzzies. But at some point, they may come in and say, well, now we have those in there. Now we want to attach some of the rights and responsibilities and obligations that are typical with guardian-ward relationships. And so those ordinances are of concern. And again, please don't look at this as just a companion animal issue. I want to spend a few minutes talking about the issue of emotion-based damages in animal injury cases. And I've been working on this for the past 7 or 8 years with NAIA, the Animal Health Institute, American Kennel Club, cat fanciers, American Veterinary Medical Association, PJAC, AHA, APPA, and a few other groups. And the issue here is that people want to seek emotion-based damages like pain and suffering or loss of companionship when an animal is injured or killed in situations where we're involved as veterinary malpractice or other types of situations like that. And Professor Rick Cupp at Pepperdine, somewhat up the road, I suppose. Well, I'm from D.C., so Pepperdine's up the road from my perspective. He explained this great, and I just want to say what he wrote. He wrote, animal rights activists have recognized that if courts or legislatures reject the market value paradigm in these cases and instead treat pets in the same way human children are treated, again, emotional distress damages are allowed to parents when their children are negligently killed, a significant legal step will have been taken toward ultimately eradicating animals' property status. And so we've been in there to try to, when the issue is in the courts, and it gets up to the appellate court levels where the appellate courts can set policy, we write amicus briefs and try to explain the issues to the judges on those courts and explain why this is not consistent with the law or actually good for animals. We do the same when we're dealing with legislatures. There's been maybe 16 states or so where legislation's been introduced on this topic, and we're in there to explain that. This is largely a domestic animal issue, but it's not solely. We just briefed a case 2-3 weeks ago where in Louisiana where someone who was a racehorse owner sued a veterinarian over a malpractice issue and asked for several tens of thousands of dollars for the emotional loss of not going down and watching the horse race anymore and being around the stables and all that kind of stuff. And that was not the key issue in that case, but if they got to that issue, we wanted to make sure that the court was knowledgeable as to how the law would lay out. In Massachusetts, and I get lots of jokes about this one, there was a case where a guy sued over lost companionship when his sheep were killed. Well, in all these cases so far, they failed, and I'll explain why. But I'll also explain where they're succeeding. But even if it's a situation where you're dealing with a companion animal, the impact might go beyond because you're dealing with veterinarians and the costs of insurance, which could affect obviously vets across the board. Farmers have been sued several times for protecting their livestock. A lot of state laws allow farmers, as you all know, to take action to shoot animals that come on their property, but that doesn't mean you can't be sued for it and then have to expend the resources and then sued for tens of thousands of dollars of emotional harm. There was a case recently where I think there was a rancher who put out some poison to try to kill some wild animals that were coming onto the property. Instead, the neighbor's dogs ran and ate the poisoned food, and he was sued for that. And so if we look at sort of where the animal rights groups have focused their energies on in these lawsuits, it's very interesting because there's been a shift because they're learning and they're adapting to the situation that's occurring. And this is where I get to the point of where we've been successful and where they see there may be some daylight. So initially they tried to focus on equating animals to children because right now in law there's humans and there's property. And there's not necessarily a third category of class of things that can be harmed. So they were trying to equate pets and animals with children. And this framing fairly uniformly failed over the past 15 years. That they tried to apply torts and legal theories that apply to family members, and that hasn't necessarily worked. People weren't willing to buy into that. But so they changed their pitch. They said, okay, well, if you don't think that they deserve to be treated as children, well, we can all agree that they're higher than a table or an ashtray, because that's what property is. So we should we should at least respect them a little higher than that. And they had a big appellate victory a year ago this month, in Texas, before the Fort Worth Court of Appeals, where the three-judge panel in that case dug up a 1963 case, for Texas Supreme Court case that said you can get some nominal emotional harm damages for harm to property, but it was called like the heirloom exception. It's one-of-a-kind property. It's something that you have only for sentimental value, and a bunch of other things that were part of it. And it said if you go out and buy something and then it becomes sentimental to you, that doesn't count. The whole point is it's like the grandma's wedding veil type case, and it was never big dollars. But because the fair market value might not adequately compensate the person, Texas had a case that made an exception. And so they just drove a Mack truck through that and said that all animals would fit this heirloom exception. And we're going to now allow unlimited sentimental damages for harm to animals. And I've been told that after the hearing, one of the judges walked off and said, well, I love my animals. It made national news. Channel, nightly news, NBC carried it. It was a big deal. We worked, again, with NAIA, AKC, and others on an amicus program and working with others. And I'm happy to say that the Texas Supreme Court took the case. There's going to be a hearing, I think it's January 8th, and hopefully we'll get that court overturned. We had other cases in Texas had gone, our way, and so there was a split. There was a Petco case about 4 or 5 years ago where they said no emotion-based damages, no sentimental value damages, and so the Supreme Court saw the split, and I'm told the Texas Supreme Court tends to be more conservative and maybe in line with our views in terms of tort law and liability law. So hopefully we'll prevail there. So they're learning how to adjust and how to frame the issues. But this lesson of learning how to frame the issues is just as important to us as it is to them. So if you walked up to someone in the street and you said, if someone wrongfully killed your pet, should you be compensated for being deprived of that pet's companionship? I think most people might say yes. But if you provide the context and you explain how the law works and the downsides, then all of a sudden you get people saying, oh, that doesn't make sense. And so that's what we're doing with our amicus briefs and with legislators and others. And so what we're focusing on is putting this issue in context, sort of legal context for the courts, the animal welfare context for animal lovers, sort of societal context for legislators who have to look beyond an individual case, and policymakers. And what we also try to do and make sure we do is we do all this together at the same time and intertwine these messages, because judges and legislators are animal lovers and people. And so we can't just talk the law to the courts. We need to make them comfortable with what we're asking them to do and not just argue the law. And to draw a parallel to what we were talking about yesterday, the same is true with science. We may have the right science, but we need to make the decision makers comfortable that if they agree with our science, that they're making the right decision in their hearts as well as in their heads. And so the legal context, and again, this is where if I get too lawyerly, someone raise their hand and I'll try to stop. Emotion-based damages for injuries to pets are not supported under American law. You have tort law or common law, and general rule there is that people who have not been physically injured themselves cannot seek emotion-based damages. There are some exceptions. Some states have something called the bystander exception. So if you witness the brutal death of a child or a spouse, then you can get, in some states, you can get emotion harm damages. And we just had a case in New Jersey this year, went up to the New Jersey Supreme Court, where this woman was walking her dog, a neighbor's dog came out, mauled her dog to death. And so she witnessed the brutal killing of her dog and tried to sue under negligent infliction of emotional distress under this bystander exception. And the New Jersey Supreme Court said, no, you can't do that. One court, I'll just read, it said, witnessing the death or severe injury of a pet is insufficient to allow a claim. A pet, no matter how cherished, is not the relative of the plaintiff. There are some states that have what's called the zone of danger, and that if you are personally in the zone of danger, even though you're not physically impacted, you can sue for your emotion-based damages. We've seen this in several places as well, including Vermont a few years ago, where we were briefing the Vermont Supreme Court on this issue. And we're talking about this case where you had a dad, a dad who was in the delivery room watching the medical malpractice that killed his child being born and risked the life of his wife. And when he sued for his emotional distress, the court said, you were not in the zone of danger. You personally were not at risk of being injured. And so we're not going to give you emotion-based damages. And then there's the malpractice case that came, and then we put it into that context and said, not only if we're going to apply, look at what the comparable situation is under medical malpractice, and in vet malpractice, obviously the owner's not anywhere near there. You can't really translate that and allow it here. And the Vermont Supreme Court also said no. There are statutes. There's things called wrongful death acts, and that is what allows people in some states to get emotion-based damages when a loved one is injured or killed. And again, these are mostly for spouses or children, not for pets. And as we discussed, there's no emotion-based damages for harm to property generally. And in the few states where it has been allowed, it's really been nominal, or as an Illinois court said, severely circumscribed amounts of damages. This is not to say that these are the only times where people are severely emotionally impacted or harmed by somebody else's wrongdoing. Obviously, it happens all the time. But those aren't compensable under American tort law. These laws, and there have been cases out there, they do not cover fiancés. They do not cover a lot of close relatives or human best friends. You don't get compensated. You can't sue when they're injured or killed wrongfully. And so, as the Massachusetts court said in the Sheep case, it would be illogical to accord the plaintiffs greater rights than will be recognized in the case of a person who suffers emotional distress as a result of the tortious caused death of a member of his immediate family. We also put this in the pet welfare context, and we explain that pets don't benefit from these liability awards, only their owners do. And the impact on pets, though, would be truly devastating for some pets. It would drive up the cost of pet care if you're dealing with the veterinary malpractice cases, where tens of thousands of dollars would be at stake every time an owner could allege malpractice. That would change the veterinary practice. Dr. Kent McClure, who I work with at the Animal Health Institute, has explained that many owners can't afford the services and the products that their pets would need if all of a sudden the animal healthcare system had to look like the human healthcare system and be driven by and include the costs of huge emotion-based damages. There was a mother who is quoted in an article recently that put her dog down over a $500 procedure. And she said it was pretty straightforward because I had 4 young children to feed. The vet said surgery was my only option. I did not want my dog to suffer. So she put the dog down. Most Americans who own pets make under $35,000 a year. At some level, the people who are making these arguments or accepting them are looking at this from a different prism. That they are, whether they're policymakers or judges or communities that have more resources and more money, they don't understand that adding a few $100s to a vet bill even over the course of a year could make the difference between responsible animal ownership and those who cannot afford to give their pets the care they need. More than half the vets have said that they've put dogs or cats down over the cost of treatment. And again, we're not talking cancer treatments, we're talking basic treatments like this. We also talk about the impact on society. There's a Wall Street Journal article that explained that sort of everybody would have to pay more liability if this were allowed. Because it's not just a small issue. Pet-on-pet aggression is at least as common as attacks on humans. And so every time, if your dog got out of the house, I know I used to have a runner, he would get out, my wife would kill me. But he'd get out and I'd go chase the neighborhood. But fortunately he was a good dog, wasn't gonna hurt anybody. But I don't know if a cat came along or a dog came along or something like that and what would happen. I don't want to be on the hook like this, if I'm a generally responsible owner, and if my kid just happened to leave the front door open and the dog ran out. All of our car insurance would go up because you'd be sued every time a dog or cat ran into the road. Again, it may not be your fault, and ultimately you may win, but you're going to have to go through, if all of a sudden tens of thousands of dollars are available to the owner, they're going to sue you. And then you'll go through all that, and you'll find out, and you may end up having to pay. We mentioned farmers protecting livestock, taxpayer resources. There are several cases going on right now dealing with police actions. And, not to defend any particular action or any particular case, but police sometimes have to defend themselves or defend, or put a dog down to protect the community. And they get sued for hundreds of thousands of dollars in liability as a result of these, of these cases. And there's one in Maryland going on right now where the family was awarded several $100,000 You have municipalities through, their stewardship of animal shelters and control programs. The Texas case involved, all these are obviously horrible situations, but a family whose dog got out, the local pound picked the dog up, owner came in within the 72-hour period, said, I'll be back with the money in a couple of days. They tagged the dog, not to be euthanized, and unfortunately, someone made a mistake. The dog was euthanized, and he came back with the kids a couple of days later to get the dog, and obviously had to find out what happened. But these are all difficult situations, difficult fact patterns, but not areas where we want to change the law. And finally, we also explained to courts and to legislatures that the higher awards are not needed for reasonable recovery. You get, under the law, your full compensation for your out-of-pocket costs. There's fair market value. You can have experts testify to breeding, pedigree, characteristic capabilities, whether offspring would be valuable. For working pets, there's replacement or training costs that are sometimes available in these lawsuits. In Oregon, there was a case a few years ago where, and this is god-awful, this guy ran his car intentionally back and forth over the neighbor's dog in front of the neighbor and his kids. And the court said, you don't get your emotion-based damages, but there's $50,000 in punitive damages and $5,000 of intentional infliction of emotional distress, which is different than the negligence stuff we're talking about. And there was a $56,000 award against the guy. And the lawyer for the plaintiffs were like, God, $50,000 on a dog killer is great. The Animal Legal Defense Fund has talked about how veterinary malpractice cases settle often for several thousand of dollars, have increased tenfold in the last 10 to 15 years without any changes in the law. And these cases often settle for $5,000 or $10,000 or $15,000. So it's not like we're talking about only the $200 fair market value that we're being talked about. But if we went the other way and we said, okay, let's allow the emotion-based damages, well, that Oregon family, they sued for $1.6 million. They got $56,000, it's not so bad, but they sued for $1.6 million. There's a Manhattan couple that recently sued a dog walking service for $1 million because the dog got out. In Massachusetts, family sued Boston for $740,000 when a dog was electrocuted walking over some live underground wires. And here in Orange County, the Orange County Animal Hospital was sued recently for $500,000. All of these based on emotion harm damages. So the results so far, we've seen these cases come up in about 35 states in the past 30 years or so for an array of these damages, whether it's emotional distress, pain and suffering, loss of companionship. They try to state it in different ways. Nearly all of them have been dismissed. And the courts have said that harms to the pets don't fit with any of these sort of time-honored categories. In legislatures, it's been tried in 16 states. Someone here, yesterday was said they're from Colorado. I think it was in 2003 that a legislator there introduced this bill, and then when he realized what he had done, when everyone sort of came out and explained the issue to him, he actually pulled back his own bill. Illinois and Tennessee both have statutes that allow for some emotion-based damages, but neither allow it in cases what we're talking about. The Illinois case is only for malicious conduct, and the statute is only for malicious conduct, and the Tennessee statute is only, it's called the Tebow Act, because the legislature there, he had his dog in his backyard, another dog in the property, came onto his property and then attacked his dog in his own backyard. And so he passed a law that said if your dog is essentially in your house or on your property or under your control on a leash and they get killed, well then you can sue somebody for emotion-based damages. So basically authorizing it in the very narrow circumstance, and then exempted veterinarians and others. And about 2 years ago, we were able to go in. Tennessee passed a sort of a general tort reform bill, and there's a provision in there that essentially freezes the law with that provision. And we were able to get in a law that said, except for what's available under current statute, there's no emotion-based damages for harm to property. And so hopefully that won't create an avenue where that'll get worse. In Nevada, we worked with legislators to specifically say in their statute no non-economic damages. Hawaii passed a bill like that about 20 years ago. Maryland says what you can get. They don't, and non-economic damages not included. And there are several organizations like the American Bar Association, but also the Council for State Governments, the American Legislative Exchange Council, and NAIA that work on model legislation, and they all have sort of been engaged in this at some level. CSG, ALEC, and NAIA have all said no, where CSG and ALEC have resolutions saying we're not in favor of this, and they've included guardianship ordinances in that. And the ABA, it's really been something where it's been a challenge. And so, as I said before, if you're inclined to join the Animal Law Committee at the TIP section of the American Bar Association, that's an area that where we can use some more help. And the plaintiff's effort to use sort of the property label as a rallying cry was that initially, I think people responded to it, but ultimately the courts and the legislature said that that's not, we understand the label, but we're not willing to change the laws to address that. And so what are the lessons that we learned from this effort that can be applied going forward? We have the better legal arguments. I mean, that goes without saying. But we also have the right message and the right messengers in terms of the animal welfare community with NAIA, Animal Health Institute, AKC, and others. And we're able to drive that wedge between the animal rights and animal welfare and help people understand why what they're asking for is not in the best interest of the animal. It's not the pro-animal position. And meet our opponents at the emotional level so that we're appealing to their hearts and their heads, not just making the legal or the scientific argument. So we are on somewhat of a slippery slope. And even in the area of animal injury damages, incremental change is happening. There are expanded economic damages. There's a few cases recently where they said you can get the reasonable necessary veterinary costs of taking care of your animal if they were injured in an accident. So the fair market value might only be, say, $1,000, but you get a $3,000 vet bill. Well, if it was just a table, we would say you can only get the $1,000, that's the fair market value. But for an animal, we want to make sure that the owner tends the animal and treats the injuries, and so we say, okay, you can get up to $3,000. And again, I think a lot of us might support that, but it's another one of those areas where we're elevating animal property interest above property interest in other types of property, or ownership interest in other types of property. Intrinsic damages or value to the owner. This is a really hot topic right now, and sort of at the issue in the Texas case, and that is because these are phrases that have real legal meaning, but they mean something different when we hear it out loud in sort of common vernacular. So if we say value to the owner, well, it's priceless. My dog, you can't pay me enough. But these are measures of damages that are still economic measures of damages. They're alternatives when it doesn't have market value, that you can say, what's the objective economic value to the owner? And this is not meant as a loophole to sort of drive the Mack truck through and get all these emotion-based damages. But that's what's being tried, and it's been rejected specifically on this point in Washington and Alaska, California, and a few other states, and that's what's at issue in Texas. And then malicious injury. These are harder cases, obviously, and in Washington State and just last month here in California, courts have approved emotion-based damages in cases where the conduct was intentional. And we haven't gotten involved in briefing those cases because it's not square in our bucket, but that doesn't mean that we're not concerned about it, and it doesn't mean that there can't be creep and incremental change along the way. And this is because our opponents think sort of in historic terms. They talk about racism and sexism and speciesism all in the same line of thinking. And it's been said that as they educate new generations and that as older generations die, they're going to start winning these issues. Those are the sort of the long-term view they have. I think the quote was, we're going to win this one funeral at a time. Again, they're not looking at this quarterly or annually based on profits. They're looking at this in terms of generational change. And so at the end of the day, it's animal welfare. We need to grab the animal welfare mantle. We need to explain that in each of the venues that the issues come up, why what we're saying is the right thing for animal welfare. If they grab the animal welfare mantle, they're going to win. And if we can grab it, then we can win and we can fight back. And especially if we can show the Animal Rights Initiative is against animal welfare, I think we do well. And the other conclusion is really to break down the silos. And this is silos within industry, as we've talked about, but also understanding that a government issue, a litigation issue, a media issue, these are all intertwined. And so we can't say, well, I'm going to say this when I'm in the member of Congress's office or the state legislator's office or the regulator's office, but then I'm saying something different someplace else. We need our messages need to be the same in each place. And we'll emphasize, obviously more technical stuff. We're talking to regulators, but the messaging of why this makes sense, why that decision maker should do what we want, and that they get it and they're comfortable with it at the end of the day is what we need them to understand. And so we need to meet our opponents on each of these playing fields. And with that, I don't know if I have any time left for questions, but I thank you for your attention this morning.